Hello friends, I hope you all are doing well. I am Dr. Gurmanpreet Kaur, Associate Professor of Law at Rajiv Gandhi National University of Law, Punjab. Today we will be discussing the topic of issues relating to the custody of children under divorce or judicial separation under Hindu law. So let's first discuss why this problem arises. So these days, divorce has become very common in the Indian society. When two people cannot get along, maybe it's the right thing to do to get separated and live their lives in peace. But the question arises about children's future. The child's custody is an important issue that requires more attention from the parents, the law, and of course the society. During marriage breakdown, resolving child custody of children becomes very critical. The child born out of the marriage is the person who is the most affected when a marriage breaks down or ends in separation of the spouses. Thus, while keeping in mind the right of the parents to the custody of a child, Indian law holds the child's welfare as the most crucial factor of consideration while deciding who gets the custody of a minor child. Now let's first discuss the meaning of the term child custody. In family law courts, it is defined as the legal guardianship of a child under the age of 18. During divorce or marriage annulment proceedings, the issue of the child custody often becomes a matter for the court to determine. In most cases, both parents continue to share legal child custody, but one parent gains physical child custody. Family law courts generally base decisions on the best interest of the child or the children. So, moving further, in general terms, courts tend to award physical child custody to the parent who demonstrates the most financial security, adequate parenting skills, and the least disruption for the child. Legal child custody is shared by both parents until the minor reaches the age of 18 or is legally emancipated. Legal custody means that either parent can make decisions that affect the welfare of the child, such as education, career, religious practices, medical treatment, marriage decisions, etc. One parent holds primary responsibility for the child's housing, educational needs, and food, and apart from other basic needs in physical child custody. In most cases, the non-custodial parent still has visitation rights. However, these are general judicial statements of a general nature, and there is no hard and fast rule that is fair, as having a hard and fast rule may not be an appropriate remedy for the child. As for the children in their tender years, it is now a firmly established practice that a mother should have their custody, because a father cannot provide that maternal affection that is essential for their proper growth. It is also required and accepted for children's proper psychological development in their tender years, making mother the indispensable. Further, it is often said that the child needs a mother the most, but it needs a father too. The question that arises is, does Indian law allow this? Is it true that the law believes that a child has a good future just because of the mother? Is it possible that the mother is always the right person in the child's life? There are times when both parents want the children's custody, and there are times when neither parent wants the children's custody. Even when mothers are engaged in the illicit legal profession, the Supreme Court has awarded them custody in some cases. In cases where one spouse is facing criminal charges for the murder or abandonment of the other, the question of custody arises. who should be granted the custody. When deciding on custody, the courts have looked into the aspect of working mothers, as they may not have time for the children. The courts, while granting custody, must look into the second marriage of one or both partners. Many a times, the child prefers to alienate himself from both parents because he is fed up with the fights. Then there is a larger issue of ego clashes between the parents, where they both harm the child without realizing it. So dear friends, let's first discuss who has the right to a minor child after the divorce or judicial separation. Both parents have an equal right to child custody. However, who gets the custody of the child is still a question that the court has the power to decide upon. Moreover, when it comes to personal laws, the statutes are conflicting as compared to secular enactment in the form of Guardian and Wards Act of 1890, which holds the welfare of the child as of a paramount importance, and thereby the court of competent jurisdiction strives to strike a balance between the two. Just because one parent is granted the custody of the children does not mean that the other parent cannot have the contact with or see the child. The courts in India ensure that the child receives both parents' attention and affection. The court determines the conditions for visitation rights granted to the other parent. So friends, moving forward, we'll discuss now the visitation rights and the different types of child custody arrangements in India. When the court awards custody to one parent, it typically grants the other parent a permit for reasonable access to the child. It is difficult to lay down specific rules on this subject given the various circumstances, which will be just adequate. Each parent should exercise the rights and privileges granted to them with good faith, discretion, and proper regard for their own rights and the welfare of the child. In India, a court of competent jurisdiction primarily orders the custody of the children in the following three forms. First, we will discuss the physical custody. So, when physical custody is awarded to a parent, it means that the minor will be under the guardianship of that parent's guardianship, with periodic interaction and visitation with the other parent. The purpose of such a custody award is to provide the child with a better life in a safe and fulfilling environment, while also ensuring they receive the affection of both the parents during their formative years. Joint custody is the next type of custody which we will be discussing. Although Indian courts believe that joint custody of the child does not imply that both parents have to live together because of the child, despite the fact that Indian courts believe that is the best for the welfare of the minor. Joint custody actually means that both parents will take care of the child turn by turn, keeping it in their custody. The child's rotation among the parents may vary from a few days to a week or even for a month. This benefits the child because on the one hand the child gets the attention of both parents, and on the other hand parents get to be part of their child's life. Lastly, let's discuss the concept of legal custody. Legal child custody of a child does not necessarily entail having the child with the parents or vice versa. Parents have the legal custody and the authority to make decisions for the child, including education and medical treatment. In certain cases where the divorce is messy and the parents do not agree with each other, the court grants legal custody to either parent, although in most cases both parents are granted legal custody together. So moving on, we will address the next question, now, that is, who has the priority claim to the custody of the child. So when deciding on the custody of the child, the welfare of the child should be of paramount consideration, as established in the case of Sheila B. Das versus P.R. Sugasri, 2003, Volume 3, SCC 62. Welfare of the child takes priority over the rights of the parents regarding the minor. Before making the decision, court takes into account the child's desire, a suitable environment, and the parents' capabilities to take proper care of the minor's needs and requirements, as held in the case of Gayatri Bajaj versus Jiten Bhalla, 2012, Volume 12, SCC 471. So if the child is over 5 years of age, he or she does not automatically transfer the minor's custody to the father. Although under Section 19 Clause B of the Guardians and Wards Act 1890 and Section 6 of the Hindu Minority and Guardianship Act 1956, a father is considered the natural guardian of the minor. The court in such cases is not duty bound to give custody to his father. In such cases, the court will first consider the child's welfare and then decide accordingly. So in the case of Surinder Kaur Sandhu versus Harbaksh Singh Sandhu, 1984, Volume 3, SCC 698, the Supreme Court has held that the welfare of the child takes precedence over the provisions of Section 6 of Hindu Minority and Guardianship Act of 1956. The court awarded the custody of the minor to the mother instead of the father, emphasizing the paramount importance of the child's welfare. Section 13 of the Hindu Minority and Guardianship Act 1956 states that to get the guardianship of a minor, one must prove that it will be in the child's best interest. In Jijabai versus Pathankan, AIR 1971, Supreme Court 315, the court refused to grant custody of the child to his father since he had not taken care of the child for a long period of time. The court, while taking the welfare of the child into consideration, gave custody of the child to his mother. Let's discuss a very pertinent question, that who gets the custody of a minor in case the mother has a weaker financial condition as compared to the father, but the father has remarried and has kids with a second marriage. So in such cases, the father cannot discard the mother as the guardian solely based on her lower earnings compared to him. In such cases, the child's father must provide for the child's upkeep. Moreover, according to the principle of law, a stepmother primarily has an obligation of affection and attention towards her own children, whereas the father would be out for the work all day, making the mother a better guardian for the minor child. So moving further, let's discuss various pieces of legislation governing child custody under different laws in India. So each religion in India has its own personal laws, which are set up for the child custody, which outline the process by which a parent can seek custody of their child. Different personal laws apply to minors of various religions, but the Guardian and the Wards Act 1890 applies to minors irrespective of their caste and faith. Some personal laws provide specific laws for dealing with the custody issues. The Hindu Minority and the Guardianship Act of 1956 and the Hindu Marriage Act 1955 deal with the minor's custody under the Hindu law. Section 26 of the Hindu Marriage Act 1955, Section 38 of the Special Marriage Act 1954 and the Hindu Minority and Guardianship Act 1956 mention the rules and regulations set for seeking the child custody. Now let's discuss them in detail. Section 26 of the Hindu Marriage Act 1955. So both parents must follow Hinduism for the custody of the child to be validated, and it encompasses the child's maintenance, care and education. Under this act, the court can pass orders, judgments, amendments, etc. at any point in time with respect to the child's maintenance and dispose of the pending decree within 60 days from the date of the service of the notice. Under Section 38 of the Special Marriage Act 1954, this act validates the child custody in cases where both parents belong to different religions or have been married in the court. Under this act, the court can pass orders, judgments, amendments, etc. at any point in time with respect to the maintenance of the child and dispose of the pending decree within 60 days from the date of the service of the notice. So, Hindu Minority and the Guardianship Act of 1956. This act allows only biological parents to seek the custody of their minor child, provided that he or she is a Hindu. So friends, let's now discuss the factors to be considered for the child's welfare. The Guardian and the Wards Act 1890 establishes the factors that the court should consider when determining the child's welfare. So Section 17 Clause 2 states that the court shall take into account the age, sex and the religion of the minor, the wishes if any of the deceased parent, and any existing or previous relationship of the proposed guardian with the minor or his property. So firstly, let's discuss the age of the child. So when deciding custody issues, it is important to take into account the age of the child. Courts typically consider giving the mother the custody of the child of a tender age because she is better suited to take care during these years. The Supreme Court held in the case of Roxan Sharma versus Arun Sharma, 2015, Volume 8, SEC 318, that courts are not bound to give custody of a child of a tender age to the mother if it is shown that it would not be for the child's welfare. The next factor is the child's gender. The Guardians and the Wards Act of 1890, it states that sex is one of the factors in determining a child's welfare. However, no provision in the law obligates the court to give the custody of a female minor to only female guardian, although the courts prioritize the welfare of the child. They are not legally obligated to give custody of a female minor to only a female guardian. So, in the case of Jitinder Arora versus Sukriti Arora, 2017, Volume 3, SEC 726, the court granted the custody of a minor girl of 15 years old to her father since it was her preference to live with her father, and the court found the same to be in her best interest. The court can grant custody of a female child to any person if it determines that it is in the best interest of the child. So, religion is the next thing to be considered. Hindu Minority and the Guardianship Act 1956 prohibits a person who has ceased to be a Hindu from acting as a guardian of a child. So, Section 13 of the Hindu Minority and the Guardianship Act 1956 allows for the overruling of this provision. The Act states that the welfare of the child shall receive paramount consideration, and this provision shall supersede any law of this Act or any other statute. The next factor to consider is the individual's characteristics. The person's characteristics also play a significant role in determining the minor's custody and guardianship. In this case, the court found the mother's behavior was not sound enough to be given the child custody. The court awarded custody to the grandmother because she demonstrated greater capability in providing a suitable home for the minor as compared to the mother. So now next we will discuss the preferences of the deceased parent. So while we consider the preference of the deceased parent of the minor, it will not be the sole criterion for the decision. We will give a great deal of consideration to the welfare of the child. So the next topic for discussion is the prior or the present relationship. In custody cases, the prior or present relationship of the person seeking guardianship and the custody with the child is also a determining factor. In the case of Islaman versus Mast Makbulan, AIR 1924, Awadh 126, the court awarded the custody of the minor to his aunt, who had a good relationship with the child, while denying the custody to her mother due to lack of interest in the child's welfare. Another factor to consider is the child's preference, which is also an important factor to be considered. Courts, when deciding about the minor's guardianship, must consider the minor's preference if he is ready to make an able decision. As per the Indian law, the age at which a child is capable of making a mature decision depends upon the case to case. The court has to consider the mental development of the child in order to determine whether he is capable of making an intelligent decision. When deciding on guardianship, the court took into account the opinion of a 14-year-old girl in Baldev versus Dhannamal, AIR 1927, Nagpur. The court will also consider the preference of the child, but it will not be binding. The court can give custody of the child against his wishes if it determines that doing so is in the child's best interest, as established in the case of Neel Ratan Kundu versus Abhijit Kundu, 2008, Volume 9, SCC 413. The child's comfort, health, material, intellectual, moral and spiritual welfare. This very broad category includes the child's adequate and undisturbed education. So lastly, we can conclude by saying that India has a strong tradition of family bonds and child care. In Indian society, children are considered blessing for both mother and father. Our culture deeply roots the idea of sharing parental responsibilities equally. When parents divorce, custody of a child remains one of the most sensitive and complex issues. Judges primarily determine custody arrangements between various religious laws and the uniform laws enacted by the state. So there has been a lot of controversy for this. It doesn't matter what perspective you take on the law. A child's future shouldn't be put at risk. Resolving various pieces of legislation is primarily about the child's welfare and social security. It is necessary to address and resolve any legal issues. Also, we can say that the legislation has not changed much when considering the custody of the children provisions, but it is good that the Supreme Court has given new dimensions to the child custody matters. The courts should not evaluate mothers based on the financial stability, distance or career orientation. We have come a long way from the case of Mrs. Geeta Hariharan versus Reserve Bank of India, decided in the year 1999. The Supreme Court is expanding its arenas, delving into new facets and incorporating the new socio-legal changes happening in the society. So despite issues relating to long distance or financial instability, mothers are given the custody today. So despite the provisions of the law, fathers have also been granted the custody. So currently, the interest of the child is the only consideration, with little exploration of the law. So with this, we come to the end of today's lecture. Thank you very much.